I'd like to welcome you all to today's session of The Law is Light. And on today's topic, we'll be talking about mediation as an alternative dispute resolution mechanism. And for that purpose, we have our distinguished speaker, Mr. Sulaiman Ramiz, with us today. And before we start today's session, let me give y'all a small introduction about today's speaker. Mr. Sulaiman Ramiz is an attorney at law working on the areas of arbitration and transactional work in areas of commercial, company, construction, and labor law. He's also a founding partner of the Moot Court Bench and also a member of the Chartered Institute of Arbitrators. With that introduction, I'd like to start today's session. So, Mr. Ramiz, my first question would be, most people think litigation is the only way to resolve disputes. Is this true?
Hi, Dulmini. Well, first of all, let me thank you and everyone at the Law Students Association of Sri Lanka for inviting me to share the little knowledge I have with you all. Most people think that litigation is the only way of resolving a dispute. Well, I can't speak for most people, but litigation certainly isn't the only way you can resolve a dispute. I suppose there are two fundamental questions that we're going to have to ask ourselves before you answer that question, right? The first question is, what kind of dispute are we talking about? And the second question is, what is your relationship with the party you have a dispute with? Say, for an example, if you take an employment dispute, right, the relationship is between an employer and an employee. In those instances, you would have certain statutory mechanisms, especially in Sri Lanka, of resolving the dispute. You could go to, say, perhaps the Labour Commission, and you can escalate it to the Labour Tribunal. Or say, for example, you could have a dispute that's a commercial matter, could be a business-related matter, intellectual property, shipping, investment, depending on the type of dispute and also depending on the relationship between the parties. Say, for example, it could be a business-to-business relationship. It could be a business-to-customer relationship. It could be a simple relationship between a parent and a child, right? And, you know, is it a good one? Is it a mature one? Is there turbulence in the relationship? The answers to these questions would kind of give us some insight as to what kind of different dispute resolution mechanisms are out there to be chosen. If it is something simple, like a business-to-business relationship, of course, there are several alternative mechanisms. Let me just highlight them for you. You have, it's called ADR in general, right? And generally, ADR can be categorized into four areas. You would have arbitration, you would have mediation, you would have neutral evaluation, and you would have expert determination, right? They kind of feed off each element. The features overlap in some instances. And each of these areas also have their own nuances. So there are different types of arbitration and there are different types of mediation. So if it's a good business relationship, then something like mediation might really help both the parties resolve the dispute and also keep the relationship intact. And I think this kind of reminds me of an important point. See, in litigation and arbitration, the approach that you take there is position-based, right? Or rights-based, where parties kind of advocate their best case scenario, and then a judge or an arbitrator would give you a decision. It's, you know, win or lose, right? But mediation and conciliation, these are more kind of interest-based dispute resolution mechanisms, where the objective is to understand what the parties really want, and based on their interests, then the mediator would kind of facilitate a discussion between them, and it might end up being a win-win situation. There is this one example that's overused in the industry a lot, but I think it's a good example to share because it really kind of sheds light on why mediation is so sought after, since it's the primary topic of this discussion. There were two people who were fighting over an orange, right? They both claimed ownership of the orange and they both wanted the orange. So if they were to go hypothetically to arbitration or litigation, they would present their best case scenario, and the judge or the arbitrator would award the orange to one person. So if one person would win and the other person would lose. But if the same dispute were to go to mediation, what the mediator does is the mediator understands what the true interests of the parties are. So once they have a couple of discussions, they kind of figure out that one party wants the orange because he wants the rind of the orange to make a delicious cheesecake and sprinkle it with some citrus. But the other party wanted the orange because they wanted the flesh of the orange to make some orange juice. So at the end of the day, they have different interests, but it was connected to the same piece of property. And it's a win-win situation where both parties walk away with what they want and the relationship is intact. So that kind of gives you some insight as to how arbitration and mediation are very different in that sense.
Thank you so much for that elaborative answer. And turning towards today's topic, my next question would be, what is mediation in Sri Lanka?
Mediation in Sri Lanka, I suppose it's like mediation anywhere else in the world, right? Again, that depends on what kind of mediation are we talking about. Because I come from a commercial law background, commercial mediation in general is a fairly straightforward process. If there's a dispute between two parties, what you would need is for both parties to agree that they would like to mediate the dispute, and they would have to select an appropriate mediator, and then the mediator will facilitate the discussion between the parties, and they would try and see whether they can come to some sort of agreement. And what has happened over time is this process has been institutionalized across the world. In Sri Lanka, there are good centers that offer this service as well. You would have an institution that takes the trouble of identifying an appropriate mediator, negotiating the mediator's fees, appointing the mediator, so that the parties involved have minimal work to do. But I'm also aware that in addition to commercial mediation, in Sri Lanka, you have, I think in 1998, they introduced the Mediation Boards Act, right? And what that did was that institutionalized something that existed for a long time. Because in Sri Lanka, mediation, I think, stems way back. Even in the days when we were colonized, you had this concept of a Gamsabha, where you had a venerable monk or a respected elder in the village who would kind of mediate community disputes between parties. So it was that process that was institutionalized through the Mediation Boards Act. And that act is, quite comprehensive. And there has been, from what I understand, quite a lot of success. There are, a significant amount of disputes that are referred to the different mediation boards across the island. In addition to that, I think there are two instances also of mediation in Sri Lanka, but they haven't been as successful. One, I think, is there was some initiative in 2001 to float a commercial mediation center. That didn't really gain traction, so that didn't go far. And I think there is also provision in the 1990 Court of Appeal rules for matters referred to the Court of Appeal to be referred to mediation. But I don't think that was operationalized. I think it requires some approval from the Chief Justice. But that, I think, is a nutshell of the different forms of mediation you would find in Sri Lanka.
Right. So moving towards the rather practical aspect of mediation, my next question is, if I want to, sort of present my case to a mediation board, do I need to go to a lawyer in order to be referred to mediation?
That was a very specific question. The mediation board, I believe, does not allow for a legal representation. So I think the Act number 72 of 1990 does not allow for legal representation at the mediation board, if I'm not mistaken. But in commercial mediation, yes, lawyers are very much present most of the time, if not always, because what happens is they're talking about large values, right? Large business contracts that are mediated. And it's important to have the lawyers because the lawyers present in those types of mediations understand how the mediation process works. So they kind of hold back their adversarial nature and they don't engage as much as they would in a courtroom. And also because at the end of the mediation, you need to enter terms of settlement, and that's where the lawyers need to sit down and reflect the agreement between the parties in legalese, right? So you can't have a lawyer represent you in mediation board. You can have a lawyer represent you in commercial mediation.
Right. Thank you for that answer. And for the next question, I actually have two parts of the question. So the first question is, what are mediation boards? And also it's followed by, how are mediation boards formed in Sri Lanka?
A mediation board essentially is a designated area, right? So if you look at the Mediation Boards Act, if I recall, what it does is it kind of identifies a particular geographical area, and that area has a mediation board appointed to them. So I think there are something over 200 mediation boards in Sri Lanka. And as to how they're appointed, well, first of all, there's a mediation board commission. I think that sits on the top, and that commission is appointed by the president. I think it's a statutory requirement for 3 of those commissioners to be retired judges of superior courts. And of course, the chairman, him or herself, needs to be a retired judge of the superior courts. Once that commission is formed, the commission can then appoint a chairman and a mediation panel for each mediation board. So, for example, Colombo is a mediation board, there would be a chairman and a panel of mediators for Colombo. It's just an example. I think it's so much more specific, like they would go to individual areas. And there are some requirements to appoint, to be appointed to a panel of mediators. I think you have to either work in the area of the mediation board, or in exceptional circumstances, they can still appoint you if you don't. I think you have to meet certain criteria. Or you can be nominated by, I think, the government agent of a certain administrative district. And you can, get on the mediation panel in that way as well.
Thank you for that answer. And to my next question, so what's the difference between community mediation and commercial mediation?
I think it's primarily the subject matter that's being discussed and the purpose of the mediation, perhaps. In community mediation, it's quite self-explanatory in a sense. It would mostly be community-based issues, right? There can be a lot of neighborhood issues caused by nuisance, sound pollution, garbage, parking, traditional things that, make us want to hate our neighbors. And commercial mediation is, again, quite as self-explanatory. I think it would be matters mostly related to commerce, business transactions, of that sort. Now, I can't really think of any specific difference in the procedure that the mediations follow, because they would largely be similar.
So my next question is, how can a person refer a matter to mediation, to the mediation boards?
To the mediation boards, I think an application has to be made to the chairman of your respective mediation board. There are certain provisions in that act, the number 72 of 1998, which kind of set out the jurisdiction of a mediation board. If I recall, the subject matter of the dispute needs to arise from that particular mediation. I think perhaps if it's related to property, it could be partially or fully related to that mediation board. So as long as it falls within the jurisdiction of the mediation board, then you can make an application to the chairman of your respective mediation board. But that's for the mediation board process. Again, in commercial mediation, there is no such restriction. You can initiate mediation simply by appointing a mediator by yourself, as long as the other party agrees to sit down with you and have a discussion.
All right. Thank you for that answer, and apologies, I just lost power. So moving on to the next question. So you told that we can refer an issue we have to one of the mediation boards. So after referring such an issue, what does the mediation process typically look like?
There is no, unlike arbitration and litigation, there is no kind of set process. There is a process that people follow, but it's not mandatory. That's what I'm trying to say. So generally what it would look like is you would have an introduction where the mediator would introduce him or herself, the parties, set an agenda as to how the mediation is going to be conducted, and touch upon certain basics of mediation, perhaps give them a heads up that mediation is a little different to what they might expect from an arbitration, and it's not an us versus them setup. It's more of a let's see how we can figure this out. And also there would be what you call caucuses, where the mediator would have discussions with parties individually and also with both parties collectively. And the purpose of doing that is for the mediator to understand the interests of the parties so that he can kind of nudge them in the right direction. And towards the end of it, make some suggestions or lay out some options that the parties can follow. And it'll be repeated as much as needed for the mediator to A, fully understand the interests of the parties, and B, for the parties to realize that they cannot come to some sort of settlement. And at the end of that process, you would typically arrive at an agreement, and it's called a settlement agreement. And generally in commercial mediation, you would have the lawyers of each parties draft that agreement for you, and it would be binding. I'm not too sure how it works in the mediation board, but I'm sure the Act would give some sort of guidance in terms of how it takes place.
Thank you. So with your elaborative answer on how the mediation process take place, I think this is a common question anyone would have. So how long does the mediation process take, like typically?
It depends. It depends on the complexity of the dispute. It depends on how willing the parties are to talk about how they can resolve their differences. But mediations can, based on those the answers to those two questions, it could last anywhere from a couple of hours to a day to weeks, even months. So you can't really say. It really comes down to the mediator and how complex your dispute is.
Right. Okay. So speaking about the Sri Lankan context, what my next question is, if someone wants to go for a mediation board, would language become a barrier for them to approach the mediation process or the mediation personnel?
I think in appointing the mediation boards for the respective areas, they would, I think, consider the language that's prevalent in those areas. For example, if it's a mediation board that's situated in the north, they would typically appoint people from that area who can speak the language and who understand the grievances of those people. In commercial mediation, it's not a problem at all because you decide who your mediator is. If there is any problem, it would be with the other party if it's an international mediation. But generally, you have a few key languages that are preferred in international commercial mediations. And I'm sure that you have, in appointing the mediation panel for each mediation board, they would have people who are conversant in different languages to satisfy that requirement.
Okay. So this is quite, I think you may be able to give a quite long answer, but maybe you could sort of just give us some points. My next question is, what are the benefits of mediation compared to a legal or a court process?
So I think that example I gave in the beginning kind of nails it on the spot. That's the best example I can give you because it's really a win-win process. But if I'm to list out some of the benefits of mediation versus courts or arbitration for that matter, the first thing is I think it's going to be significantly cheaper because in litigation you would end up paying a lot of money to your attorneys, and in arbitration you would end up paying a lot of money for your attorneys and also for the arbitrator. And the second thing is, I think you would save a significant amount of time because mediation is flexible, procedure can be adapted based on the complexity of the dispute. You don't always have to follow a set mechanism, versus in court and arbitration, regardless of whether it's a small dispute or a large dispute, you kind of have to follow the steps, the procedural steps to the dot. Otherwise, it can be thrown out sometimes on a technicality. So you can definitely save time. And I think the most important thing is the position-based or rights-based adapproaches, which are adversarial in nature, like arbitration and litigation, often end up as a very bitter experience. And mediation does the exact opposite. The aim is to make sure, the priority is to make sure that the relationship between the parties remains intact, whether it's community or commercial. And I think that's the biggest win in mediation. Yeah, those are I think some of the key benefits of mediating a dispute over going to court or arbitration.
Just a side question from that very question. So, are mediation processes completely free?
Again, it depends. I think I'm not sure. I'm not sure about the mediation board's processes. If I'm not mistaken, I believe it is free because I remember reading somewhere that it's a voluntary service. The mediators on the mediation panels for mediation boards are public servants, and I think therefore it's free. So yes to that, but definitely not for commercial mediations. Mediators are paid by the other in most cases. So it depends on what type of mediation we're talking about.
Thank you. Okay, so we are moving towards the last question of the day. So in a normal court process, we have the option of appealing. So what are the options available if you are not satisfied with the outcomes of the mediation process?
Well, it's quite straightforward, right? At the end of the mediation, you have a choice. You can either agree to settle the dispute or you can disagree. It's just one of two. There's really no two ways around it. If you agree to settle the dispute, then you can sign an agreement saying these are the terms of the agreement. Or sometimes, in complex disputes, you can agree to settle certain elements of the dispute, and the others you can then take to court or arbitration. So it's I think it's important to understand that what the mediator does is that he or she basically facilitates a negotiation between two parties who have a dispute. So nothing is forced on them. There is no coercion of any sort. So the agreement at the end of the day is purely an agreement between the parties. If they want it, they can take it. If they don't want it, they can leave it as it is. And that I think is also another benefit of mediation. But there is no appeals process. There is no need for an appeals process because it's an agreement between the parties.
Okay, thank you so much, Ms. Rami. So those are my questions for the day. And to proceed, I'd like to invite Nirmal.
You're most welcome. It was very nice to be able to be of assistance.
We would like to express our gratitude to Mr. Sulaiman Ramis for joining us today despite his busy schedule to explain us about mediation. We believe that your explanation answered many of the public's questions about mediation. Also, we would like to thank our sponsors, Scholars Guild and Prudential Shipping, for sponsoring this webinar series. Also, I would like to express thanks to our President of the Sri Lanka Law Student Association, Seenat Sakir, and Secretary of Social Welfare Committee, Dulmini Gamage, for their immense contribution for this project. We would also like to thank all of you, the audience, who stayed with us until the end. We will say goodbye for you today, hoping to meet you in another similar program. Good night.